Hello, and welcome back to our channel. Today, we're diving into a topic that can impact individuals and businesses alike, bankruptcy law. Whether you're someone struggling with debt, a business owner facing financial challenges, or simply interested in the legal field, understanding bankruptcy law is crucial. Stick around to learn what bankruptcy law is, how it works, why it's important, and much more. Let's start with the basics. What is bankruptcy law? Bankruptcy law is a legal framework that allows individuals or businesses unable to repay their debts to seek relief through the court system. This law is designed to help debtors by eliminating or restructuring their debts while ensuring fair treatment of creditors. Bankruptcy laws vary by country, but the primary goal is the same: to provide a fresh start for those financially overburdened while protecting the rights of creditors. In the United States, bankruptcy law is governed by federal law, primarily under the Bankruptcy Code, which is found in Title 11 of the United States Code. Different chapters of the Bankruptcy Code, such as Chapter 7, Chapter 11, and Chapter 13, serve different types of debtors and offer various forms of relief. Now, let's talk about how bankruptcy law works. When someone files for bankruptcy, the process begins with submitting a petition to the bankruptcy court. This petition includes detailed information about the debtor's financial situation, including assets, debts, income, and expenses. Once the petition is filed, an automatic stay is put into place, which temporarily halts all collection activities from creditors. The bankruptcy process differs depending on the type of bankruptcy filed. For instance, under Chapter 7, known as liquidation bankruptcy, a trustee is appointed to sell the debtor's non-exempt assets to pay off creditors. Once the assets are sold and the creditors are paid, the remaining debts may be discharged, meaning the debtor is no longer legally required to pay them. On the other hand, Chapter 13 involves creating a repayment plan that allows debtors to pay off some or all of their debts over 3 to 5 years. This type of bankruptcy is often chosen by individuals who have a regular income but need help catching up on overdue payments without losing their assets, like a home or car. Why is bankruptcy law important? Bankruptcy law plays a critical role in the economy and society. First and foremost, it provides a safety net for individuals and businesses facing overwhelming financial difficulties. Without bankruptcy law, people could be trapped in a cycle of debt with no legal mechanism to reset their financial situation. For creditors, bankruptcy law ensures an orderly and equitable distribution of a debtor's assets, rather than a chaotic rush to claim whatever they can. This structure helps maintain trust in the financial system, as creditors have a legal framework to recoup some of their losses. Moreover, bankruptcy law encourages economic risk-taking and entrepreneurship. Knowing that there is a legal recourse in the event of financial failure, individuals and businesses are more likely to invest, innovate, and take risks that drive economic growth. Let's look at some specific rights guaranteed by bankruptcy law. One of the most significant rights is the automatic stay, which immediately stops most creditors from pursuing collection actions against the debtor once a bankruptcy case is filed. This gives debtors breathing room to work through their financial issues without the stress of constant creditor harassment. Another right is the discharge of debts. Depending on the type of bankruptcy, many of the debtor's obligations may be wiped clean, giving them a fresh start. However, it's important to note that not all debts are dischargeable. For example, student loans, certain taxes, and child support obligations usually remain after bankruptcy. Debtors also have the right to retain certain exempt property. Exemption laws vary by state, but they generally allow debtors to keep essential items like clothing, household goods, tools of the trade, and sometimes even a home or car, up to a certain value. Now, let's discuss job opportunities in bankruptcy law and the average salaries for each role. 1. Bankruptcy attorney. These professionals specialize in representing either debtors or creditors in bankruptcy proceedings. They provide legal advice, prepare necessary documents, and represent clients in court. The national average salary for a bankruptcy attorney is around $92,000 per year. 2. Bankruptcy paralegal. Paralegals assist bankruptcy attorneys by preparing documents, conducting research, and managing case files. They play a crucial role in ensuring that the bankruptcy process runs smoothly. The average salary for a bankruptcy paralegal is about $50,000 per year. 3. Bankruptcy trustee. Appointed by the court, trustees oversee the administration of bankruptcy cases. They are responsible for liquidating assets, distributing funds to creditors, and ensuring compliance with bankruptcy laws. The average annual salary for a bankruptcy trustee varies, but can range from $60,000 to $120,000, depending on the volume and complexity of cases. 4. Credit counselor. Credit counselors help individuals manage their debts and explore options for avoiding bankruptcy. They provide education on budgeting, credit management, and debt repayment strategies. The average salary for a credit counselor is approximately $45,000 per year. 5. Financial analyst. Financial analysts in bankruptcy cases assess the financial status of companies or individuals, helping to determine the best course of action during bankruptcy proceedings. They earn an average salary of about $65,000 per year. What skills are required for people working in bankruptcy law? Professionals in bankruptcy law need a diverse set of skills: legal knowledge. A deep understanding of bankruptcy laws, procedures, and case law is essential. This includes familiarity with different types of bankruptcy and the specific requirements for each. Analytical skills. The ability to analyze financial documents, assess debtor situations, and develop strategic solutions is crucial in this field. Attention to detail. Bankruptcy cases involve extensive paperwork and documentation. Missing a deadline or detail can have serious consequences, so attention to detail is key. Communication skills. Clear and effective communication is important when dealing with clients, creditors, court officials, and other stakeholders. Negotiation skills. Whether negotiating a repayment plan or settling a dispute between creditors, strong negotiation skills are invaluable. Empathy and compassion. Many clients facing bankruptcy are going through a tough time. Being able to empathize and provide support can make a big difference in their experience. Bankruptcy law is not without its challenges and controversies. For example, some argue that it can be abused by individuals or companies looking to escape financial responsibilities without truly needing relief. Others believe that bankruptcy laws should be more lenient to accommodate those with overwhelming student loan debt. In any case, bankruptcy law remains a vital part of the legal landscape, providing necessary protections and helping to balance the interests of debtors and creditors. We hope this video has provided a clear overview of what bankruptcy law entails, how it works, its importance, and the career opportunities within this field. If you found this video helpful, please give it a thumbs up, and don't forget to subscribe to our channel for more informative content on legal topics. Thanks for watching, and we'll see you in the next video.